And a couple of things before we get started. If you are okay with turning on your video, I'd love to see faces. I don't mind seeing letters. I don't mind seeing names, but I'd love to see your faces. It helps me to see faces when we're talking. And if you don't mind, drop into the chat the ages of your kids, because the second thing that is really helpful to me is to kind of know not who specifically, but kind of the ages of the kids that are behind what I suspect is the reason that you're all here. So that helps me a lot to know who it is you're planning for, who it is you're trying ultimately to protect. And we are going to take questions at the end, and mechanically, here's how we'll do questions. You can drop them into the chat as we go along. You don't have to wait till the end to type your question then. You could type it as we go along. If it occurs to you and you don't want to lose it, get it in the chat. Do me a favor though, put the capital letter Q at the beginning of your chat comment before the question. And that way, when we're going back up, scrolling back up through the chat, it's easy for me to pick out the questions as opposed to the comments. All right, let me take a look at what we got here. Awesome. Well, you guys all have young kids. I guess that's what I would expect from the Bedford Family Network. Awesome. Awesome. Thank you so much. Okay, so I'm David Feeks. I am the owner and founder of the Parents Estate Planning Law Firm. We are in Acton, right on the Littleton line. If you know Nagog Office Park, that is where our office is. Estate planning is what we do all day, every day, day in and day out. And our primary focus in the office is on families like yours, on families with young kids. I started planning this way when my kids were still young. I figured out where all the gaps in traditional estate planning were for families with young kids, because I recognized there were gaps in our own plan when my kids were still young. And I figured out how to fix all of those potential problems, how to fill those gaps. I built all of those solutions into our plan, and now we build it into the plans of all of our clients. And one of the reasons that we are out in the community, and by community for the last year and a half, I mean on Zoom, teaching, but before then, literally in the community, teaching parents what they need to know about planning, is because planning for your families, planning for your kids, in many ways is more complicated than even your parents' planning. And the reason is because you've got young kids, and your kids, for the most part, aren't able to take care of themselves. They may think they can get themselves dressed in the morning and can get themselves out the door, but if something happens to you, they need someone to take care of them. They need someone to take care of them physically. They need someone to take care of the financial resources that you leave behind that are designed to make sure that they have everything in life that you wanted them to have, and everything that you would have provided to them if you were still there. And we sincerely hope and expect that you all will be there to watch your kids grow and become intelligent, competent adults that will go out and make their own way in the world. But planning, like life insurance, is all about, but what if I'm not? What if I'm not? We want to make sure that the right things are in place. As we say, better to have a plan and not need it than need a plan and not have it. So the first thing I want to do is I want to acknowledge you all for being here tonight. And I want you to acknowledge yourselves for being here tonight. I know that we enticed you with mixology, that, you know, we gotta ease you into this. But for the rest of our time together, we're going to talk about some things that aren't particularly easy for you to talk about or even think about. And some of you, I dare say, probably most of you, have put off thinking about these things. And when these thoughts kind of bubble up in your head, sometimes at 3 o'clock in the morning, when you're staring at the ceiling, you try to push them away. And I know that most parents, if they grab onto those thoughts for any length of time, can get frustrated or may run away because there's something they know they need to do, but they don't know exactly what doing looks like. And even if they do, they don't exactly know how and where to get started. So that's what we're going to talk about tonight. What does doing look like, and how and where can you get started on all of this? Because if I leave you with just the doing part and I let you go off into your lives, your kids are gonna, when they wake up tomorrow morning, I hope all of them for the most part are asleep right now. When they wake up again tomorrow morning, your lives are going to become the kind of chaotic daily routines that they are, and you are very likely to forget about what we talk about tonight. So I want to give you some really good concrete next steps that you can take. As I alluded to before, the planning that we're talking about tonight is, again, what I figured out for my own family. So you get the benefit tonight of everything I've learned along the way. And by the way, my kids are older now. I've got a 21-year-old and a 24-year-old. So I'm going to give you 24 years of parental experience and planning experience. And so you can just ride my coattails tonight. I'm happy that you do. So in terms of housekeeping, we're going to be together for about the next 40 minutes or so, give or take. Again, questions in the chat, put the letter Q in front of your question, and then we'll know it's an actual question when we go back. So I will save enough time. I will hang around for as long as you guys have questions. Sometimes we knock off questions in a couple of minutes, and sometimes we're answering questions for 15 or 20 minutes. It's fine. I've got nowhere else to go for a little while. So my time is yours. I'm not providing you legal advice tonight. So that's an important thing to point out and for you to know. We have not created an attorney-client relationship by joining each other in this webinar. I'm not giving you legal advice. I'm giving you an education, but I'm not giving you legal advice. And again, we're not creating an attorney-client relationship. So my goal here is for you to walk away with a better idea of what it takes to create a rock-solid plan for your family and how you can get started on that planning right now. So let's dig in. One of the things that Meredith mentioned is that there are 4 essential ingredients in a cocktail: ice, spirit, mixer, garnish. Surprisingly enough, there are 4 essential ingredients in a really good estate plan, and we're going to go through those 4 ingredients tonight. They are, in a particular order: plan for your kids, plan for your money, plan for your incapacity, and then finally plan for legacy. And that's a little bit of a different one for most people, but I think it'll make a lot of sense when we get to it. So plan for your kids, plan for your money or your assets, plan for incapacity, and plan for your legacy. So let's start with planning for your kids, because I'm pretty sure, other than the cocktails, that's why you all showed up tonight. You've got young kids. If something happens to you, they can't take care of themselves. Here's the most important thing for you to know. If something happens to you and you don't have a plan, a probate court judge is going to decide who takes care of your kids until they each turn 18. 18 is when they become legal adults. They don't need a legal guardian anymore when they turn 18. But if you've got no plan in place, a probate court judge is going to decide this for you. There is no default guardian. There's no one who automatically becomes your kid's guardian. Your guardian has to be appointed by a probate court judge. And if you have not left them instructions on who you want, then a judge who during the day sits in Woburn in the Middlesex Probate Court is going to do the best that they can. But what they can't ever know, unless you tell them, is what's most important to you, what's most important for your kids, who you want to take care of your kids, and sometimes, as important, who you don't want to take care of your kids. Because some of you, this is just raw numbers, some of you right now listening to me have somebody in your immediate family that you know you don't want to be the guardian of your kids. That maybe you're a little afraid they might be standing in front of a probate court judge arguing that they should be the guardian of your kids. And the reason I know statistically that some of you are in that group is because about 40% of the clients that we work with are indeed in that group. And I freely admit that when my kids were young, there was someone in our immediate family who Paul and I knew we didn't want to be the guardians of our children. And so we had to make a plan around that as well. So when you're thinking about guardians, I want you to think in two distinct timeframes, one of which I'm sure you've given some thought to. The other one, I'm willing to bet a lot that you haven't given any thought to. And by the way, the reason you haven't is because no one's helped you to think about this. The time frame you've probably given some thought to is the long-term time frame. What happens if we die? Who do we want to step in and care for and love and raise our kids until they have all turned 18 and they no longer need a formal legal guardian? I'm pretty sure this happened to me. I have talked to enough parents to know that I'm almost positive this happens to every single parent, that when your first child is born, sometimes even before, sometimes when you first know you're going to have a child, some kind of internal warning system gets triggered inside of you that nags at you over and over and over again, sometimes loudly, sometimes softly, that basically says to you, you are now responsible for an entirely separate life form. And you need to do something to make sure if you're not there, that child or those children are cared for, because they are your response. You have to take care of them. And if you're not there, you got to make sure somebody will take care of them. So I know that warning system is going off, and I know it's been nagging at some of you. And again, you just don't know what to do with that. Long-term guardians are, for most of you, the answer to that nagging warning system. If I name guardians, once you name guardians, that nagging warning system goes away. Now you've got a plan. Your internal system doesn't need to nag you about that anymore. We're going to come back to the long term in just a minute. Here's the other time frame that most of you haven't thought about. And again, it's because no one has helped you to think about this. Your parents' estate planning attorney won't help you to think about this because they're busy helping people who are your parents' age. Your parents don't have kids that need a caregiver. You guys are old enough to manage your own resources, but you all are the parents of kids who can't. And so if your long-term guardian is not immediately available, think about where your long-term guardian lives, or who you would want your long-term guardian to be, who you would nominate. Think about where they live, and think about how long it would take them to get to your kids in an emergency. For some of you, it might be 15 or 20 minutes. For some of you, a half an hour. For some of you, an hour. For some of you, several hours. I have lots of clients whose long-term guardians are outside the United States. Under the best of circumstances, it might be days before they could get entrance into the United States, sometimes weeks. In a pandemic, they're not coming at all. So for the last year and a half, they've not been able to come at all. So what you want to have as part of your plan is a short-term piece. People who live close to where you live, who can fill that gap. We'll talk a lot about gaps. Who can fill that gap between the moment something happens to you or the survivor of you if you're married, and the moment your long-term guardians can arrive and take over. Now, for me, it was 2.5 hours. That was the time gap for my kids. My kids were very often home with a teenage babysitter. Paul and I used to go out on a standing date night every other Thursday night. And one night coming home from our date night, we got talking about what would happen if a police officer, if we were in an accident, a police officer shows up on our doorstep. Does our babysitter know what to do? We realized our babysitter doesn't know what to do. Our babysitter has our cell phone numbers. Maybe they have the neighbor's number in kind of a non-critical emergency. But if a police officer showed up on our front door, we knew our babysitter, 17 years old, responsible, mom was the school nurse in town, but our babysitter didn't know who our guardians were, how to contact them. Our kids would be asleep upstairs. They wouldn't exactly be able to articulate what to do. And even if everybody could figure that all out, it would take 2.5 hours for my sister, my brother-in-law to drive up from Connecticut. So I had to go figure out how to make sure in that 2.5 hour gap, my kids wouldn't be removed from my home and placed in the custody of the Department of Children and Families. Because fundamentally, that's what's going to happen if your kids are with a caregiver and there's no clear plan and your long-term guardians are not immediately available to them. I know this from my police officer clients. I know it from my state trooper clients, and I know it from my clients who work for DCF. I've talked to them all. Here's the solution. The solution is identifying people who do live close to where you live. Think about a 15 or 20-minute travel radius around your house. Think about the people you know and trust who live in that radius. People you know and trust, people your kids know and trust. And then the idea is to give those people, or some subset of those people, the legal authority to be with your kids on a short-term basis until your long-term guardians can arrive and take over. And that way, you know, in an emergency, somebody can come right over. If it takes your guardians a couple of hours to get there, or a couple of days to get there, someone else is there to step in and take care of your kids, and they have the legal authority to do that. So if a police officer shows up on your doorstep, there's a plan, there's someone who knows how to execute the plan, and there are people close by who can step in who are part of that plan. So I wanted to start there because I know most of you probably haven't given that some thought. And as a result, most of you, had you not met us tonight, would have created a plan that did not include short-term guardians. You would have thought you'd gotten everything all taken care of, but in reality, you would have been walking around with a leaky bucket of an estate plan. And sadly, I review many, many, many existing leaky bucket estate plans. I help them fix it, but there's too many leaky buckets out there. I don't want you to have a leaky bucket. So that's the short-term time frame. And then back to where we started, long-term guardians, again, the people you know and trust to raise your kids as close to the way that you would if you were still there. Whoever that is, it might be family members, it might be friends. There are no hard and fast rules about who this should be. It is merely who you think is the best candidate to fill that role. And then planning is all around making sure those people are appointed and documented appropriately. So if something were to go wrong, those people could step in and take care of your kids for the long term. And that means planning for what happens if you die, but it also means planning for what happens if you don't die. Again, we've got a year and a half behind us that taught us that we might not be able to take care of our kids for an extended period of time. If we're in the hospital, if we're sick, if we're incapacitated. So you want to make sure your guardianship plan covers not just what happens if you die, but what happens if you're alive and can't take care of your kids. And again, I see too many traditional estate plans that don't cover incapacity. And so again, another place where gaps can very often exist. And then it's just a matter of making sure everything gets documented appropriately, everything gets signed appropriately. One of the questions I got at our last mixology webinar that I was answering in a Facebook Live today was, do I have, if I do my own plan, do I have to have witnesses? As if doing your own plan, suddenly you didn't have to have witnesses, or if you have a formal plan, you do. And the answer is yes, you got to do it right. And too many people, when they try to do their own plan, don't get it all right. So it doesn't work when they need it most. So those two pieces, short-term guardians, long-term guardians, put that together, and that is a really good plan for your kids. In our office, that's what we call our kids protection plan. With that plan in place, from the moment something happens to you or to the survivor of you if you're married, until your youngest child turns 18, there's somebody all along the way to care for them, love them, raise them, guide them. And for parents of young kids, that's always my very first recommendation, is that you at least get a guardianship plan in place for your kids. And we'll talk a little bit more in a bit about how you can get that in place. So the next thing I want to talk about is planning for your money or for your assets. Again, you've got young kids. If you were to die, they can't manage the resources that you leave them. They need someone else to step in and take care of those resources. And the most important thing I think that most people discover as part of the estate planning process that maybe they weren't aware of before is just simply what's going to happen to their assets. What's going to happen to your assets if there is no plan in place? So If you don't have a plan in place, so essentially you own all of your assets in your own name, or names if you're married, sometimes jointly, sometimes you have separate assets, or if you've named your young kids as a beneficiary on things like life insurance or retirement accounts, probably you name your spouse first, but if something happens to your spouse, a lot of people name their kids as their secondary beneficiary. When your kids are young, as to any assets you own in your own name or where you've named your kids, young kids as a beneficiary, if you die, those assets are going to get swept into a probate court process. And some of you may have experience, for better or for worse, dealing with a probate court, maybe because a parent died or a grandparent died and you kind of saw what happened. Here's what happens. First of all, the probate process is designed to identify the assets you own at the time of your death. The court will appoint someone, that person is known as a personal representative, and that person's job is to identify all the assets you owned at the time of your death, to get appraised values for those assets, to report those assets to the court. The court's going to give your creditors a period of time to make claims against those assets. But ultimately, the court's job is to supervise the distribution of your assets to what we call your heirs at law. Your heirs at law are simply defined by law. So for those of you who don't have a plan in place, your heirs at law are going to inherit all your assets. Here's the good news. The good news is your kids are your heirs at law. If you die, your kids are your heirs at law. That's where the good news probably ends in this conversation for most of you. Everything else is probably not ideal. Maybe it is, but experience tells me with talking with hundreds, if not thousands, of young families that it probably isn't. Probate has drawbacks. The first of which is it takes a long time. It takes at least a year to probate an estate in Massachusetts. It cannot be made to go faster. That is the creditor claims period. It takes at least a year. It can take longer, but it's never going to go faster. So it's a long process. It's an expensive process. The court involves filing fees and publishing fees and accounting and appraisal fees and legal fees and executor and trustee and bonding fees. And because your kids are young, they need someone to manage resources for them. And that person that gets appointed by the court is also getting a fee for managing the resources of your kids. So there's an ongoing expense as well. You can figure on thousands, if not tens of thousands of dollars to go out the back door to pay people you don't know to do things that are not important to you and that will not make a material difference in your kids' lives. So it's long, it's expensive, it's cumbersome. And by that, I mean your families won't have immediate access to your assets while they're going through probate. And if they need access for any reason, because your kids have healthcare needs, or they need daycare expenses paid for, or college, or food, or clothing, or shelter, your family's going to need permission from the probate court to get access to those assets. And that permission can take weeks, sometimes months. So there's not going to be immediate access to those resources. Again, the court is going to appoint someone to manage all of these resources for the benefit of your children or your child. And that person is simply going to be appointed by the probate court, which means that it is almost assuredly going to be a stranger to your family who's managing these resources for your kids. Your guardians will be dealing with ultimately this stranger. And the court may appoint different people if you have more than one child, because the court will not assume that your children's economic interests are all perfectly aligned. With no plan in place, when your kids turn 18, they're entitled to inherit what has been left behind for them. Now, that's whether or not you think 18 is an appropriate age. It's whether or not they would be financially mature enough to make wise decisions about what to do with those resources at age 18. If you want to, you can just pause here for a moment, think about who you were and what you would have done when you were 18 if somebody had pushed a pile of money across the table to you and said, here you go, best of luck. I can see some heads shaking. No, 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 no. But that's what happens by default. You can change that plan, but that's what happens by default. And then the last thing to know about probate is that it's public. Anybody can wander into the probate court. And by the way, the Middlesex probate court is in Woburn. It used to be in Cambridge. couple of years ago, they moved it up to Woburn with the rest of the court complex on 128. Anybody can wander into the probate court Monday through Friday, 8:30 in the morning till 4 in the afternoon, and pull out all of your probate documents. They can see who your kids are, how old they are, where they live, who's taking care of them. They can see what assets you owned at the time of your death, what the value of those assets were. They essentially can figure out when an 18-year-old is about to inherit a substantial amount of assets. And for better or for worse, there are people who spend time in probate court looking at that stuff. They can read all of this information. They can make copies of all the documents, and they can walk out the door with the copies in their hands. And so I find most parents are not tremendously comfortable with the idea that somebody can discover when their kids are about to inherit a substantial amount of assets. So that's probate as a process. Now, if I let you consider that for a moment and then ask you, does that sound like it's okay or not okay? I'm going to get back about 95% of the time. And again, I've been doing this for a long time, so I've gathered a lot of statistics over the years. But 95% of the time, the answer to that question is not okay. I don't like that. I don't want my family to go through that. I would prefer that things were easier, more seamless, more streamlined, and that someone have near immediate access to my assets so that my kids can be cared for, and that my guardians are not paying for expenses out of their own pockets. Here's the good news. The good news is that probate does not have to happen for your family. Your assets don't have to go through probate. You can avoid the whole process altogether. It doesn't happen automatically, though. You've got to plan for it. The way you avoid probate, at least the only foolproof way I have discovered to avoid probate, is to create as part of your plan what we call a revocable living trust. If you're abbreviating, that's an RLT. Estate planning lawyers love to abbreviate everything into 3-letter and 4-letter acronyms. RLT, Revocable Living Trust. It's a trust that you create while you're still living. If you're married, you and your spouse can create it together, probably would create it together as a joint trust. You create it while you're living, you manage it while you're living, and you are the beneficiary while you're living. And the idea of the trust is not simply to create it, but to create it and take your existing assets and move them into the trust. You retitle your house in the name of the trust. You create a new deed that transfers your house into the trust. You retitle your bank accounts in the name of the trust. You retitle your taxable investment accounts in the name of the trust. And on things like life insurance and retirement accounts, you change the beneficiary designations. So instead of going to your kids, those assets would go into a trust. And you appoint someone to step in as a successor trustee if something happens to you or to both of you, again, if you're married. Now, while you're still living, all of the assets in the trust are still yours. You use them the same way you do right now. Your bank accounts are still your bank accounts. Your investment accounts are still your investment accounts. You put money in, take money out. You can use it for anything you want. Your house is still your house. You pay the tax bill, you pay the mortgage. If you want to sell your house, the sales process is exactly the same as if you own the house in your own name. You have the right to revoke the trust. You have the right to amend the trust in any way you want, as long as you're living. Here's the difference. When you die, the assets in your trust do not have to go through probate. There's no court that needs to get involved to figure out where trust assets go, because they're in the trust. They're in the trust when you're alive. They stay in the trust when you die. The only difference now is who's managing all of those resources. You were when you were alive. Your successor trustee takes over if you die. So now we got no probate process. Your trustee has immediate access to your assets. We don't got a year-long process. We don't have to pay for that process. We don't have predators who can find out. The trust is private. Everything about the trust stays private. Nobody knows what's going on in the trust, what the assets of the trust are, that your kids are the beneficiaries of that trust. And you get to decide in the instructions in the trust how and when your kids get access to those assets. If you don't want them to get money at age 18, if you would rather have someone else take care of the money for them to pay for their college, tuition, room and board, spending money, you can decide your kids get access to that money later, and you get control over how they get access to that money. One of the other benefits of a trust, aside from avoiding probate, is that it gives you the power to protect the money that you leave to your kids. Because as hard as this is to imagine, when your kids are really little, someday they will grow up and they will become adults. And when they do, they may run into problems in their adult lives, the way some of us have run into problems in our adult lives. They may have creditor issues, they may get sued, they may choose the wrong spouse. So if they get married and then they get divorced, ordinarily their assets are marital assets subject to division in a divorce, but the trust gives you the flexibility to build a structure in that says if they get married and then they get divorced, the money that we have left to them is protected. So it can't be taken away by a creditor, by someone suing them, or by a future divorcing spouse. The third benefit of a trust is that you can build in estate tax savings into the trust. In Massachusetts, the estate tax, the estate level estate tax, the estate tax that the Commonwealth collects, triggers at $1 million. What counts towards that $1 million? The equity value in your house, your bank accounts, your investment accounts, your retirement accounts, and for a lot of you, here's the kicker, the face value of the life insurance policies that you own. If you're over $1 million, an estate tax would be due when the survivor of you dies, and it would be due 9 months after the date of the death of the survivor of you. Over $1 million, you're looking at least a $39,000 tax bill. At $1.5 million, $70,000. At $2 million, $106,000. Keeps going up from there. The trust allows you to eliminate that estate tax up to $2 million if you're married. So instead of paying $100,000 on estate taxes, your family pays zero, which means there's an extra $100,000 for your kids that can be invested to grow over time to be more for them. The trust gives you the ability to get those estate tax savings. So probate avoidance, making things as easy as possible for your family, estate tax savings, and the ability to protect the money that you leave to your kids when they become adults and throughout their adult lifetime. That is the benefit and the beauty of a revocable living trust. And with the clients that we work with, about 95% of our clients self-select into what we would call a trust-based plan, or a planning level that we offer that includes a revocable living trust. Again, because they mostly want things to be as easy as possible for their family. So that's number two. That's the second ingredient, planning for your money and for your assets. Third ingredient, planning for incapacity. Shorter conversation. If you become incapacitated, you will need someone to step in and make decisions for you, to take care of things for you, whether those things are medical decisions, whether it's related to healthcare decision-making or legal decision-making or financial decision-making. If you're incapacitated, you'll need someone to do this for you. And here's what you need to know if you're married. Your spouse does not automatically get to do this for you. Most people think, my spouse will be able to step right in and do things for me. They'll be able to make medical decisions for me. They'll be able to go into the bank and access my bank account. They'll be able to sign legal documents on my behalf. The answer is no, they will not. They don't automatically get to do this. For medical decision-making, as a practical matter, purely as a practical matter, if you're incapacitated in the hospital, your spouse is standing there, and a healthcare provider needs a decision to be made on your behalf, your healthcare provider is probably going to look at your spouse and say, what do you want us to do? But they're not required to do that. And if the last year and a half has taught us anything, it's that spouses aren't always in the room with you. Sometimes they're at the other end of a FaceTime. And so the only way you can be absolutely positively sure that the person you want is going to be able to make decisions for you is for you to create a plan so that they can. And for healthcare, here's how you do it. Number one, you create a healthcare proxy. That's the legal document in Massachusetts where you name someone to step in and make medical decisions for you if you can't make those decisions from yourself. Now, some of you may already have a healthcare proxy. Little wave of your hand if you think you have a healthcare proxy. I'm going to if we were gambling right now, I'd probably be about to win a lot of money, because I can bet with about 99% accuracy that you got your healthcare proxy from the hospital, or yeah, there go the heads. You got it at the hospital when you were being treated for something at the hospital, or maybe having a child at the hospital. And when they admitted you, they said, they're thinking, something could go sideways here. Do you have a healthcare proxy? And you said, I don't. And they said, would you like one? And you said, I guess so. And so they handed you a form and you filled it out, probably your spouse first, maybe your parent or a sibling second, and you signed it, and they had a couple people come in and witness it, and now you have a healthcare proxy. Good, that's better than nothing. As we say, some plan is better than no plan, even if it's not the perfect plan, but it's not the greatest form. I know the form very well. I've seen it a million times. It's not the best form, but you should have a healthcare proxy. You should also, and this is where the hospital form falls flat, you should also have what we call a HIPAA authorization or a HIPAA waiver, because most of you are familiar with HIPAA, the federal medical privacy law, which says your healthcare providers cannot release identifiable healthcare information about you to anyone else without your written consent, and that includes your spouse, and that includes your family. So what happens is, without a HIPAA waiver, there can be barriers in communication and barriers in information gathering for the people who actually have to make the decisions for you. You want them to be able to make good, informed, intelligent decisions for you, and they sometimes need to get access, excuse me, to your medical records in order to do that. So you need a HIPAA waiver or a HIPAA authorization as well. And then the third medical document is called a living will, and that is essentially a roadmap that you leave for your decision makers about how you want them to make decisions around life-sustaining treatment. You're not going to recover a meaningful quality of life. Do you want to be kept alive artificially or not? And the living will gives you the opportunity to leave that guidance, to leave that roadmap for your decision makers. On the other side, we've got legal and financial decision making. And this is done through one document. It's called a durable power of attorney. And again, spouses don't automatically get to do these things for the other. But a durable power of attorney would allow someone else to step in and make legal decisions for you, to sign legal documents, to sign a deed, to sign a tax return, to get access or to manage your bank accounts or your financial accounts, to reallocate the investment mix in a 401k or an IRA, or to be able to manage those on your behalf, to do things like go to the post office and pick up your certified mail, manage your social media accounts, essentially to do all of the things that you're used to doing for yourselves on a day-to-day basis. But if you're incapacitated, you wouldn't be able to do those things. With a durable power of attorney in place, now someone else can step in and do those things for you. So those four documents together are a great incapacity plan. Again, healthcare proxy, HIPAA waiver, living will, and durable power of attorney. So that's the third ingredient. Here comes the fourth ingredient. And again, this one is a little bit unusual. You don't hear about this a lot, but it is an awesome piece of a good estate plan. And in many ways, it'll be the most meaningful piece for your families. Excuse me for a minute. And this last piece is a plan for legacy. And here's how you can think about a legacy plan. Think about all of the things that are, you may not think of it this way, but they're inside of you right now that you know you want to share with your kids, with maybe the people who are going to take care of your kids, or the people who are going to manage the money to take care of your kids. Think about all of the things that you would want to share with them, things you would want to tell them, things you would want them to know. Think about all the things that you're thinking about. Hey, when my kids are old enough, I'm going to share this, or I'm going to tell them this, or I'm going to teach them this, that you've not yet had the opportunity to share or teach or tell because they're not old enough yet. Now, imagine for them, these are all things that are inside of you. They're intangible. They're part of you. They're important to you. You want to get them out. You will get them out. But here's the thing. If something happens to you, they're gone forever. And unless you have captured those things, the stories, the memories, the guidance, the advice, unless you've captured that in some meaningful way, something happens to you, it's gone forever. If you want, you can think about someone who is no longer in your life, who you would give anything right now to hear their voice again? There's lots of people whose voices we can't hear anymore that we'd like to hear again. If something were to happen to you, your kids would want to hear your voice again. Your guardians may want to hear what you have to say, but unless you capture that in some meaningful way, they just can't. And so what we've done in our firm is we have developed a way to help our clients capture that as part of their estate planning process. It is called our Family Wealth Legacy Interview. It's very, very simple. We sit down together, we take out a recorder. When all the documents are signed, when the formal plan's in place, then we create what we call the informal plan. But again, probably in many ways, the most important part of the plan. We sit down with a recorder. I interview clients. We record it digitally. Now you have an audio recording that you can leave behind, again, for your kids, for your family members, about all of those things that are most important to you. Paul and I did ours about 11 years ago when our kids were still preteens. It was the coolest 45 minutes I'd ever spent talking about my daughters with a colleague of ours who helped us to record it. And I have recordings from people in my life. I have an audio recording about an hour long from my paternal grandmother that was recorded when she was in her 90s, literally about 6 months before she died. And after my father died and my stepmother was cleaning some things out, she sent it to me just randomly in the mail. She said, I know this is what you do. You probably would be interested in listening to this. It's all about your grandmother. And for the next month, I listened to that on a repeating loop. The only place I could listen to was a CD. The only place I could listen to it was in my car. The only place left that I had a CD player. And my daughter now has that card, and she listened to it this summer. I got to hear things about my grandmother I never knew about her. It's fascinating. My other grandmother, I have a family story that's written, but I don't have it in her own voice. And what is it, as I say to people, and I tell my kids, when I read the story, which I do from time to time, I can still hear my grandmother's voice when I read the story. But my kids don't have the benefit of that. They never really got to know her alive. They never really got to know her voice. Even if they read the story, they cannot hear it in her voice. So I think that part of the planning is a really important piece. I think it's really important for you to preserve things for your kids. And you may start to think about this for your own parents. Hey, what can we do to get mom and dad, or mom or dad, or if your grandparents are still alive, to get some of those stories captured while you still can? Because I promise you, you will never regret it. And here's the interesting thing. All of us every day are walking around with a voice recorder in our purse, wallet, or pocket. Every day, all day. We wake up, we've got it. Till we go to bed, we've got it. We could be doing this every single day, but we don't, which is why we've built it in as part of our process. Because I know if I make it part of our process, then we can carve out the time to actually get it done. So that's plan for legacy. So there you go. Plan for your kids, plan for your money and your assets, plan for your incapacity, plan for legacy, put all of that together. Now you have got an airtight, gap-free, rock-solid plan that protects your kids, that protects your money, that protects your legacy, and makes sure that your kids, your family, have a bright, bright future, even in a potentially dark time. Now, as I said earlier, if I just leave you there and I check out now, great, you'll have gotten an education, but what are you going to do with all of this? How are you going to put these pieces together? How are you going to turn what you learned tonight into something meaningful and concrete for your family? Before I give you an option on how to get that done, here's a question I want you to ask yourself, because I really want to let this and have this settle in for you. Here's the question. Knowing what you know now, knowing what you learned here tonight, do you want to leave things the way they are right now for your family? Do you want to leave things the way they are? Or do you want to change them? Because if you don't want to leave things the way they are, if you want to change them, the next question is, what are you going to do about that? Because if you don't do anything about that, nothing changes. And your assets will still go through probate, and a probate court judge will still decide who's going to take care of your kids. And they may get it right and they may get it wrong. And if you're sick and unconscious in the hospital, your spouse may or may not be able to get access to your bank account or take care of things for you. And if you die, you may or may not have a legacy that's left behind. It may die with you. So you've got to do something about that. So what are you going to do about that? What I want to do is I want to give you a pathway. I want to give you a foothold into taking the next step. What that looks like in our office is our family wealth planning session. It is a 2-hour meeting. We literally set aside 2 hours on our calendar for you. And here's what we do with those 2 hours. In the first hour, we do an extended exercise of what we've done here tonight. A deep dive into where are you now? Where would you rather be if where you are is not where you want to stay? And to the extent that there's a gap between those two things, how can we get you from where you are to where you want to be? But it's really all about helping you to get really, really clear about where you are and really, really clear about where you want to be instead. Because that's the only way we can help you to get between those two places, is for you to know exactly where you are and exactly where you want to be. That's the first hour. After that first hour, you've got a pretty good idea. Here's what I need to do. And then you'll make a decision. Am I ready to do it or not? And if you're ready to do it, and we're a good fit for you and you're a good fit for us, and we make the decision to work together, then we've got the second hour where we can actually help you start to design that plan, so that you walk away from that first 2-hour meeting knowing I've made a decision to get a plan in place. I've made the decisions for that plan. And now David and his team are creating that plan for my family. And I know that very soon I'm going to come back. We're going to sign all those documents. And then I'm going to know I've got a great plan in place for my kids and for my family. So for all of you, to thank you sincerely for joining us tonight, I want to offer that to you. And in a second, I'm going to tell you how you can get started in getting that 2 hours on our calendar. But here's why I say sincerely, we offer that. And I want to share that with you as a thank you for joining us tonight. Because our firm, but our firm by extension, we all have a mission. Everybody who works for the firm buys into this mission. It's Paul and my mission, but everybody who works with us and for us has bought into this mission. And that mission is never to stop doing what we do until every single child in Massachusetts has the comfort of knowing that their parents have created a plan for them. So that if mom and dad aren't there, somebody will be. And that those children will be cared for physically, and they'll be cared for financially, and they'll be cared for emotionally. And we cannot stop, we will not stop until that happens. And it will never happen in my lifetime, but we keep plowing, doing what we can, doing what we can, doing what we can. So for that, I thank you for joining me, because now you have helped me to further that mission. You are ambassadors for our firm in that mission. So I sincerely appreciate that. In exchange, we will happily give you 2 hours of our time. If you would like to take advantage of that, here's how you can do that. The first step is to schedule an intro call with our client services coordinator. Her name is Lori, and she will schedule 15 or 20 minutes in her calendar to talk to you, to see whether we're a good fit for each other, to kind of understand a little bit more about you, what you need, and to help you know if we're a good fit for you. And so she can know if you're going to be a good fit for us, and if everything's aligned, and we might be able to work together to get you scheduled on our calendar. Now, the mere fact that you schedule on our calendar does not, you're not bound to hire our firm. You'll only do that if you decide after the first hour whether it makes sense for you. But if it does, we've got that time set aside. But again, the first step is to talk to Lori. You'll really like talking to Lori, by the way. Lori is awesome. She is an awesome director of first impressions. She's been with us for a little over 4 years. So Paula has dropped into the chat a link that you can click. It'll take you into Lori's online calendar. and you can schedule that initial call with her. And if it seems that there's a good fit, Lori can get you scheduled on our planning calendar for our family wealth planning session for you. We're also going to drop into the chat links for some guides that you can download for more information. I think for most of you, the appropriate one is going to be our Kids Protection Planning Guide, and you can download that, and it'll just give you something that you can refer back to over and over again. A lot of what we talked about tonight, and even some things we did not talk about tonight. So we'll drop a link in there. We'll also drop a link in for our Empty Nesters Guide. I suspect all of you got the younger kids, but if you want to grab a hold of the Empty Nesters Guide, it's all about planning when your kids become adults and your planning shifts and tweaks just a little bit to reflect those changing circumstances in their lives and in yours. Okay, so we've got the call link with Lori in the chat, the guide downloads, those links will go in the chat. I want to scroll back up and see if there's any questions. And remember, questions begin with a Q. How is it that I'm not seeing any questions? Nope, hold on. That might have been, there we go. And you can start to type them in now if you want to. One question, can you talk about different types of trusts? I'm a bit confused by realty trust, revocable living trust, joint tenant with rights of survivorship. Let's take joint tenant with rights of survivorship. That's not a trust. That's just a form of ownership. So if you and your spouse, for example, own a brokerage account together or a bank account together, you own it jointly. It's essentially joint tenants with rights of survivorship. If you and a sibling were to buy real estate together, you could buy the property as joint tenants with rights of survivorship. And all of that means is that you own it together. And if one of you dies, the survivor of you owns it alone. That is the right of survivorship. So that's it. For those of you who are married and you own real estate, you almost always own it husband and wife tenants by the entirety, which is basically the same thing. You own it together. If one of you dies, the other of you owns it solely in your own name. So that's joint tenant with rights of survivorship. A realty trust, sometimes called a nominee trust, is a kind of revocable trust, but it's not really an estate planning trust. It's just a different form for owning real estate. So if you didn't want to own real estate in your own name for some reason, and there's lots of reasons why, privacy being one of them, you can create what we call a nominee trust, and then you could take title to property in the nominee trust, and then you could be the beneficiary of the nominee trust. So that's what we call it. That's essentially a realty trust. And then a revocable living trust is just an estate planning trust. When we say RLT or revocable living trust, generally estate planners understand that as an estate planning trust as opposed to any other kind of trust. But there are all kinds of trusts that are revocable trusts. It's just that when we say revocable living trust, it's generally understood to mean an estate planning trust. There are also irrevocable trusts. They're beyond the scope of our conversation today, but all an irrevocable trust is a trust that you cannot revoke and you cannot use the assets of while you're still living, and you do not manage on your own. So thank you for that question. Any other questions? Feel free to kind of type them in. If there's no questions, it usually means I've done a magnificent job explaining everything. Hold on. Good thing that my Zoom tells me when there's a new one. Will our long-term guardians for our children need to have an RLT as well? Short answer, no. Your RLT holds the assets. Now, whether or not your guardians are the managers of your trust is a different story. That's something that we talk more about in an initial consult in a family wealth planning session about the advisability of having the same person manage the financial resources as who's going to take care of your kids. Because there's there's quite a bit of a conflict of interest there. So no, your guardians don't need to have their own RLT or revocable trust. The expenses for your kids can be paid out of and should be paid out of the revocable trust that you leave behind. So then the second part, Is this something we should speak to them about ahead of time to make sure? No, so you don't need to talk to them about having their own trust in place. They may have their own trust, but they don't need their own to take care of your kids. But I would say that talking to your guardians ahead of time about being the guardians of your kids is absolutely positively something you want to talk to them about ahead of time. Guardians are not bound to accept their appointment. They can decline. So you want to make sure the people you want to nominate are going to be able to care for your kids, want to take care of your kids, and you always want to have a backup in case something happens to your long-term guardians. It's not very hard to imagine a scenario in which you and your long-term guardians are all riding in the same car together when that car goes off the side of the road. After you said all of this initial, what kind of maintenance is required and what would trigger the need to make changes? So there is no required maintenance. What we do is we invite all of our clients to come in at least every 3 years for an ongoing plan review meeting. I think about 3 years is a good period of time to pull your plan out and take a look at it and review it and see if there needs to be changes. Sometimes the answer is yes, sometimes the answer is no. For families with young kids, those changes tend to happen more rapidly than when you get to be our age, my age, with my kids as adults. So that 3-year cadence seems to work really, really well. If things happen that might trigger a change before then we sit down before then. What might trigger a change? Somebody who's playing a role in your plan is no longer appropriate. They've died, they've become incapacitated, or you don't talk to them anymore, or you don't like them anymore. The short-term guardian, you had a neighbor as a short-term guardian, the neighbor moved away, they can't be the short-term guardian anymore. Or you moved away and now you need a whole new set of short-term guardians. Your kids get older, that triggers, you bought a new house, you sold a house, you changed a job. Those at the end of every year, even though we do a 3-year formal review, at the end of every year, we send out a checklist to all of our clients that basically says, have any of these things happened in the preceding year? And if the answer to any of these is yes, you should probably pick up the phone and call Lori and see if we shouldn't get up on the phone together and talk about whether or not this triggers a change in your plan. And again, sometimes the answer is yes, sometimes the answer is no. Those tend to be the things that trigger changes. Basic estate planning, what does it typically cost? No worries about stepping away. Kids are kids. I did a 2-hour meeting today with a 7-month-old, right in the middle of it. For a long time, I looked at the ceiling fan. That's what they had their camera pointed at. It was okay. We got it done. We got a plan in place for them. What does it typically cost? There is no typical cost for an estate plan. Don't go cheap. Do not try to get this done on the cheap. Let's give it some context. How many of you have a climbing structure or a swing set in your backyard? Any of you? Kids not old enough yet? You will. How many of you have been, what was it called? Childcraft in Acton? Anybody been to that store in Acton? It's by Circle Furniture. Anyway, in Acton, that's when you drive around Acton, Boxborough, Littleton, Concord, you see these structures. They're brown. And one day I was kind of perusing the cost of these structures because it's been like a million years I remember it was like a couple $1,000 to buy a swing set for my kids. And it wasn't fancy in any way. It didn't have a slide. It didn't have a tower or any kind of the childcare. Those structures cost thousands of dollars, right? You can spend $4,000. You can spend $10,000 on those structures. And people do. I had a client and we were talking about planning levels and we were reviewing the planning levels. And the client said to me, and I thought this was awesome. And I asked him if I could use this forevermore. And he said, sure. He said, I feel like it's our obligation as parents to at least spend as much on our estate plan to protect our kids as we spent on the play structure that sits in the backyard. I said, that's awesome. That's the greatest thing I've ever heard. And when we were all done, I said, how'd you do? He said, pretty much right on the nose. We pretty much just spent about the same amount of money on our estate plan as we spent on our play structure. You can go cheap on this. You can, think about vacations. You can go camping in a tent. You can stay at Courtyard by Marriott, or you can go all in for a Disney World on property vacation. Camping, cheap. Courtyard by Marriott, a little more expensive. The Disney vacation, think about what the Disney vacation costs. How many of you have taken a Disney vacation? Show of hands, anybody? Oh, guys, you got a lot coming. Start saving your money, man. The big stuff is ahead of you. A Disney vacation, you could spend anywhere between $10,000 and $20,000 on a Disney vacation. And people do it. And people do it year after year after year because they love going on a Disney vacation. Would it be worth spending what you would spend on a Disney vacation 1 year, one time, to buy a plan for your family? And by the way, that's not even what it costs. But you're going to spend a few $1,000s on a good comprehensive estate plan. And if you find somebody who says you can get a good comprehensive estate plan for $1,500 or $2,000, I'm telling you right now, run as fast as you can in the other direction, because they are not good at what they're doing. You cannot do it for $1,500. You can't, you just can't. Our team has figured out what it takes to build a really good estate plan, and we've priced accordingly. And you can't do it for $1,500. You cannot sustain that. It's like Walmart. You just can't sustain it. They can because of volume. Estate planning firms cannot sustain that. So if you get it, they'll go out of business soon enough, and then you'll kind of be stuck with it. So you got to plan to spend a few $1,000s. Now, we have different planning levels. Some people spend a few thousand, some people spend more, but we always leave it up to you. What's important to you? What do you value? What are you trying to accomplish? And even within trust-based plans, there are options that can be built in, and you decide whether you build them or not build them, and whether you spend a little extra money or not. So it's entirely up to you. But that was a long answer to kind of a short question, but really the answer is there is no short answer to that question. Anybody whose every estate plan costs exactly the same is doing you a grave, grave, grave disservice. Yeah, Paul was making sure I get to everything. What about guardians who are grandparents and you want to build in a switch to a younger person in the event that the older couple is not able to keep up? I talked a little while ago about backups and what I refer to as redundancy in your plan. If you're thinking about your parents as guardian for your kids, you may be realizing, my kid is 1 year old and my parents are how old? And this is a 17-year span until my child is 18. Can my parents make it? They may not. That's why you want to have a backup plan. Because if the time comes, your parents are not prepared to take on your teenager in their 80s, you want to make sure there's a backup there. And if something happens to your parents, you want to make sure that there's a backup there. My general advice is choose whoever is appropriate for your kids right now, and don't try to worry about 5 years from now or 10 years from now or 15 years from now. Don't try to plan that far out. Plan for what's appropriate right now, knowing that you can change your plan along the way. And in 3 years or 5 years or 10 years, you can come back and change the plan if your parents have aged out of that role. Okay, hopefully that helps. But yeah, older grandparents can't always keep up with either your younger kids running around pell-mell all the time, or even worse, your teenagers. Your parents don't want to come back and be the parents of teenagers again. They've done it already. They have the scars to prove it. I have the scars to prove it. I think we got everything. Did we, Paula?
Yes.
Paula says yes. Okay, so we'll leave the links up for a little bit. We'll leave the room open for a little while, even as you guys kind of head out. If you want to click on that link and make an appointment with Lori, go ahead and do it. And I honestly encourage you to do that, to get something, at least to have that conversation. Again, no commitment at all. And if you want to download those guides, feel free. We'll leave the room open so you don't have to rush through that. And I thank you all for joining me. And if there's anything we can do for you in the future, don't hesitate to reach out to us. The number in the office, 263-6900. And you can always reach us at support@parentsestateplanning.com. Support@parentsestateplanning.com. Again, guys, it was great to talk to you tonight. I really appreciate our time together. Again, we'll leave the room open. I'll play a little more music if you want to grab those links and just hang out for a second. But we'll talk to you again soon. Take care, everybody. Have a great night.
Thank you.
They said they were going to send the recording around to everyone too, in case you missed anything.